starting in 5 seconds. Honorable members, keeping in mind the desire of the youth to be self-reliant, the Kaushal Vikas Abhiyan was launched. Under this Abhiyan, in the last 4 years, on an average, 1 crore youth have been trained every year in different skills. In the coming days, more than 15,000 ITIs, more than 10,000 Kaushal Vikas Kendras, and more than 600 Pradhan Mantri Kaushal Vikas Kendras will play a critical role in developing the skill set of the country's youth. Under the Pradhan Mantri Mudra Yojana, which facilitates credit for professional and business requirements, loans worth more than rupees 7 lakh crore have been disbursed to the youth without any guarantee. More than 15 crore people have benefited, and over 4 crore 26 lakh first time borrowers have started their business under this scheme. Under Startup India and Stand Up India, my government has provided financial assistance to make the youth self-reliant. As a result, in the world of startups, India now figures as a frontline country. The government has linked creation of jobs with tax incentives under Pradhan Mantri Rozgar Protsahan Yojana. Under this scheme, when a young person gets a new job, the EPS and EPF contribution of 12% payable by the employer is being paid by the government for the first 3 years. More than 1 crore youth have already benefited from this scheme. Every parent aspires for a good education for their sons and daughters so that they can succeed in life. Government is establishing new educational institutions to provide increased opportunities for professional education of the highest standard. 7 IITs, 7 IIMs, 14 IITs, and others are being established. It has been decided to enhance the amount of scholarship and fellowship by more than 25% to encourage research activity in the country. In addition, efforts are being made to further strengthen the foundation of the education system by opening 100 Kendriya Vidyalayas, Ekalavya Model Avasiya Vidyalayas in all talukas having a majority tribal population and 62 new Navodaya Vidyalayas. To improve the standard of education, government is following a multidimensional approach. To secure the future of the country, it is imperative that children still studying in schools get full opportunity to transform their imagination into concrete reality. Honorable members, with changing times and evolving technology, methods and processes of employment and business are also changing. My government is constantly working to ensure the preparedness of youth of our country for such changes. My government is making efforts to identify talented sportsmen from different corners of this country under the youth-centric Khelo India program. Transparency in selection processes has boosted the morale of our sportspersons. The result is reflected in the number of medals won by us at national and international levels. Our daughters are making remarkable contribution in every field today, and have brought laurels to the country. It is for the first time since independence that the policies and programs of the government have created numerous new opportunities for enterprise for women and led to their empowerment and economic mainstreaming under the Pradhan Mantri Mudra Yojana. The maximum benefit has been availed by women. Out of the 15 crore Mudra loans provided so far throughout the country, 73% have been disbursed to women entrepreneurs. Under the Deen Dayal Antyodaya Yojana, about 6 crore women have become members of the self-help groups. My government has provided loans worth more than rupees 75,000 crore to such self-help groups. This amount is 2.5 times more than the loans given in the 4 years proceedings 2014. In order to ensure the participation of women entrepreneurs in small and medium enterprises, it has been made mandatory for the major government companies to purchase at least 3% of their materials from the enterprises owned by women entrepreneurs. My government is also making efforts to address the problem of gender based discrimination faced by women in different spheres. Last year, a decision was taken whereby women officers recruited under the Short Service Commission in the armed forces would be considered for permanent commission through a transparent selection process just like their male counterparts. Women who had been deprived of employment opportunities in the underground mining sector even after so many years of independence will now be given equal opportunity to work in this sector. To enable working women to devote more time towards the upbringing of their new born children during the crucial formative years, the government has enhanced maternity leave from 12 weeks to 26 weeks. Despite the scorching sun, heavy downpour, snowfall, or any other challenge, the hard-working farmers of our country have toiled day and night to produce record food grain harvest. There has also been an increase in dairy and fish production as also in other areas. Many of you have witnessed village life and the struggles of the farmers. Our farmers are not only the foundation of our economy but they also keep our traditions alive. Stop. Starting in 5 seconds. Sir, there are 3 items which are covered by this bill. I support the 3 items because this bill symbolizes and represents a new national development of having a consensus on certain basic questions. It is also a happy augury that the approach is not a negative approach and it is not being said that the preamble of the constitution insofar it has been changed by the 42nd amendment in respect of its secular or socialistic character shall go. It is not said that the list of fundamental duties shall go. It is not said that the directive principles which were amended to provide for workers' representation or for legal aid or for conservation of natural resources will go. That is a healthy development. So far as the Congress party is concerned, it has approached the question with an open mind. Regarding the government proposal, with regard to internal security, the Congress party has made it clear as a result of experience that it is opposed to internal disturbances as such, and it is against the retention of a clause as to internal disturbances in the event of the armed rebellion. As a result of recent experience, we as the Congress party stand by those provisions of the 42nd Amendment, such as the amendment to the preamble or the directive principles, and we also say that there should be no power in Parliament to declare an internal emergency. But I would like the Law Minister to consider this question not merely from the point of view of the 42nd Amendment, but from the point of view that the Constitution should become a dynamic instrument of socio-economic change to deal with the basic questions that are before the nation. Why did we think of the constitutional amendments? Why did the first constitutional amendment come? Why did Panditji come to the parliament with the first constitutional amendment? It was because our legislation for the abolition of zamindari was struck down. Why did Pandit Nehru come to Parliament in 1955 with the fourth constitutional amendment? Again, it was because our socio-economic legislations were struck down. Therefore, when we consider a constitutional amendment, we have to consider the problems that had arisen. Certain property rights, which became part of the fundamental rights, had stood in the way of various socio-economic legislations like land reforms, etc. Sir, we find that in the Golaknath's case, it was laid down that Parliament had no power to alter the fundamental rights, which included the right to property. Sir, you would recall in the Golaknath case, the justice had said that if the aim was to introduce a socialistic pattern of society, then it was a mistake to incorporate property as a fundamental right. It is that mistake which was revealed in 1950 when land legislations were struck down. It is that mistake which was revealed in 1953 when in Bela Banerjee's case the Supreme Court said that full compensation has to be paid. It is to rectify that mistake that in 1955 Pandit Jawaharlal Nehru introduced the Fourth Amendment to the Constitution. It is that mistake that resulted in the setting aside by the Supreme Court in February 1970 of the Banks Nationalization Act. It is that mistake that resulted in setting aside in December 1970 of the provision for the abolition of the privy purses. Today, sir, when we discuss this question, we have to discuss the basic question of the conflict that arose as a result of Golaknath's case, by which the property right became supreme and by which the power of Parliament to amend was nullified. With regard to that, we must have a fresh look. The Supreme Court in that important case tried to take a second look and overruled the Golaknath's case, and that there is a concept of the basic structure of the Constitution. What happened in the Golaknath's case? Parliament's right to amend the Constitution, the fundamental right, was taken away. In that important case, a doctrine of basic structure was introduced. but the doctrine of basic structure as now developed by the Supreme Court is undefined and it is unchannelized. The question has now come before the Parliament to finally decide on these basic questions. First, we have to decide what is this basic structure. There has been two urges before the parliament. One is the socialistic urge to fight against inequality and to introduce socio-economic legislation. The obstacle here has been the fundamental right to property. There is another urge of parliament, that is the democratic urge to preserve life and liberty. This should also be given place in our constitution by the Indian Parliament. The property right which stood in the way of bank nationalization, stood in the way of abolition of the privy purses, and also stood in the way of abolition of the zamindari system that has to go in totality. Stop. Starting in 5 seconds. Sir, the other day when I initiated the debate, I spoke only for 5 minutes, and during that time I made a reference to Article 39 of the Constitution. I also submitted that in a period of 51 years of our independence, states could not implement the directive principles with reference to that. I also made a mention of the exception of the West Bengal government and the government of Maharashtra. I was discussing the question as to the necessity of the introduction of this particular bill. I said at that time that on many occasions we referred to the problems abroad. For example, when there is a price rise, it is usually said that there is a price rise in all countries and therefore we cannot help it. It is with reference to this I would also like to invite the attention of this august house and the honorable minister as to what is the position abroad. As far as this is concerned, if we have a look to other constitutions, a reference of which has been made to the constitutions of the world, we find there are about 21 countries in the world wherein this right to work has been recognized, and out of these 21 countries, China, Japan, USSR are there. Not only this, Ireland, from whom we took the inspiration for independence, has also included this right to work as a constitutional right. Not only this, but there are other countries also who, though have not included the right to work as a fundamental right in the constitution, have provided for unemployment benefits. We find that there are about 28 countries which include Switzerland, Sweden, and Australia. It is because of this I would request the Honorable Minister for Law and Justice to consider the constitutions of these particular countries who have recognized this particular right, and then consider whether the time has not come after 51 years of independence, and especially when we could not implement the directive principles, whether the time has not come now to consider very seriously this particular problem as to whether this right should be enshrined in our constitution as one of our fundamental rights. As far as our country is concerned, the government of West Bengal unanimously passed a resolution to this effect without exception of all the parties. I would also like to invite the attention of the House to Rule 23 of the Declaration of Human Rights, which makes a provision of this right to work, and a directive has been given that all developing countries should provide such a right as a fundamental right in their constitution. This matter was debated. There was an amendment to refer the matter to a select committee. The matter was referred to a select committee, but in the meantime, Parliament was dissolved. I would appeal to the Law Minister to accept the amendment of my friend, the founding father of our Constitution, in the Constituent Assembly, said that political democracy cannot survive without economic and social democracy. It is in this background also that we have to take into consideration this particular aspect. The demand for this right to work to be included in the Constitution has been made by many youth organizations. The Janta Yuva Morcha, Yuva Janta Morcha, and the Congress Youth Organization and other youth organizations have all passed resolutions in 1996 and 1997 and requested the government to include this particular right in the Constitution. Not only that, I believe that there is no opposition to this bill because my honorable friend, who is not to be seen here now, has introduced a similar bill number 81 of 1997, where he mentions that where a citizen is not provided with work to enable him to earn his livelihood, the state shall render him assistance with unemployment allowance. When a similar bill was moved in the last parliament, the present minister was very eloquent in his support and said that they should be included in the constitution immediately. I do not know whether he has changed his mind because of the change of his position from this side to that side. I believe not. There is one more to which I would like to invite the attention of the House Justice Khanna when he was addressing the 15th annual convocation of Punjab University, said the commitment relating to right to work under Article 39 and 41 has, in the face of mounting unemployment, a strange ring of irony. These articles, he said, pose a question for all those who had been in charge of the affairs of the state as to how far they have carried out the mandate. He pleaded for solid hard work for carrying out the constitutional mandate. Lastly, there was a public demonstration by all the youths before the house of the Prime Minister here. Stop. Starting in 5 seconds. Sir, if all financial powers are distributed to the states and all sources of taxation are divided between the states, then how is this to be done? Therefore, even though the government of India collects several taxes, it is not as if they are all used for central government purposes. They are transferred to the states and not transferred in any way. A finance commission sits every 5 years and they suggest how it is to be done and that is accepted. Then there is again the planning commission. If the country is to develop as a whole, unless there is a central planning commission, the states will go on doing things differently for different areas, and there will be, I am afraid, not development but cancellation of each other's development that can happen. We see what quells we have about the distribution of voters, about the question of the sales tax. There is a demand that the sales tax should be converted into an excise tax. We have said we should like to do it. I have always believed in it, but unless the states agree, we cannot do it. And I do not want to take away that power of the states. Therefore, we have to go on persuading them. If they agree, then a lot of corruption and a lot of harassment to people will have gone. But there are states which are well to do, and there are states which are not well to do. The well to do states do not want this conversion, the others want the change. Now we are not thinking of the whole country. All the states do not think about it. When they begin to think about it, I am quite sure that things will be solved much more easily. But we have to work for it. Should we not see that there is a binding link for all the states which see to it that there is no division of the country or any account? And if that is also one of the purposes of the central government, it must have powers which enables it to do so. Can the military be disturbed between the states? It cannot be. But what is the demand here? When the question of law and order comes, the opposition wants to blame the treasury benches for its deterioration. The position under the constitution is that the states are responsible for law and order, but the opposition insists that we must act. Will you enable me to act in that manner? I would not like to take away those powers. We should help them in a manner to promote their interest in the state itself, and where the states fail to maintain law and order, I would rather change the government by having elections. That is how the people will come up, otherwise, they will not come up. Ultimately, our strength lies in the strength of the people. On the question of the reorganization of a state, we know what happened. These are the things which happen in this country. Today, wherever you turn, you find there is the desire for division, not unity. Should we not change it? Will the states be able to do it by themselves if they are left free? If the central government has to keep themselves back, will they be able to do it? We are not yet able to agree on a common language for all of us because we have rich languages in every state. In a big country like ours, this is inevitable. Before freedom, most of the people from all parts of India had agreed. After freedom, it is a matter of controversy. That controversy also is to be resolved by common consent, and we have to work for it. We have to go on struggling for it. But who is to work for it except the center? Will the states work for it? They cannot do it. The arrangement in the constitution is that it is like a necklace of pearls or diamonds. The string which goes through the necklace gives it strength and gives it beauty. If that string breaks, then all the pearls goes and they lose their value. That is what happens, and that is the function which the central government ought to perform. The function of the government of India cannot be to dwarf the states, it is to strengthen states, and it is in strong states and in strong center that the advantage of a country lies. The interest of a country can be preserved only when both are strong. This demand for removal of these powers or those powers is not intentionally made for any other purpose. I hope except to see that the states become stronger. I can understand that position, but it can be taken advantage of by some people to see that the country breaks. Then we shall not be able to do anything concrete here. Stop. Starting in 5 seconds. I am truly delighted to be here in your midst to celebrate the 40th anniversary of the Institute of Defense Studies and Analysis. I am particularly happy that you have chosen on this auspicious occasion to honor your former director for helping to lay a strong foundation for this institution in its formative years. His incisive writings continue to stimulate and contribute to the thinking of strategic analysts and policy makers in this vital area of national concern. We look forward to many more years of active contribution from this doing of the strategic community in India to the vital policy debates of our times. Over the years, he has pointed out in his writings the importance of making strategic choices that affect our national security and well being by careful weighing of cost and benefits without getting trapped in black and white views of the world, ignoring the shades in between in which the real world manifests itself. He has been an ardent advocate of a holistic vision of national security tempered with a sense of realism and pragmatism. Let me therefore suggest that, in keeping with our known principle on the need for long term planning, we use this anniversary celebration to on strategic policy planning in journal and on IDSA's contributions to this process in particular. On balance, I think it is fair to say that over the past 4 decades, IDSA has largely fulfilled its missions. While the existence of IDSA as one of our few strategic think tanks suggest a deeper need to create an adequately vibrant strategic community. This is perhaps a subject for study in its own right. Suffice here to say that I believe your institute has rendered great service, often in difficult circumstances, to promote strategic thinking, inform policy makers and the public at large, and to develop a community of strategic thinkers. I congratulate all those associated with this institute for contributing to strategic studies and institution building in a vital area of national concern. However, an anniversary is also an occasion to objectively consider the lessons of the past and to strategize to meet the challenges of our future. I would like to briefly outline the challenges that confront us today. It is a truism that despite the progress humankind has recorded, war, disease, and ignorance, we can therefore draw no comfort from the trends that determine our future. Optimists suggest that the present security challenges will at worst persist, but pessimists forecast total devastation. Pragmatists suggest that security problems will worsen over time but probably incremental. Personally, despite my own training in the dismal science of economics, I am inclined to be more optimistic than the optimist. Perhaps Bonar Law was right when he said that there is no such thing as an inevitable war. If war comes, it will be from the failure of human wisdom. I believe that peace in our troubled and violent age requires eternal vigil, patience, and wisdom. We must all work together to analyze potential sources of conflict to find solutions without recourse to arms. It is this that is the challenge before governments and humankind as a whole. It is in this context that centers of research and think tanks derive their importance. Policy making in most countries is often reactive. Governments are driven by deadlines and events, and once an event occurs, it is a bit late to plan for it. This is one reason why so many problems are difficult to resolve. Proactive planning is the goal of strategic thinkers worldwide, and this is where your community must step up efforts to identify problems, highlight trends, develop scenarios, and suggest policy options before crises overtake us. I have often said and felt that there is a dearth of long term planning. Of course, there is a saying of a very famous Cambridge economist, Lord Keynes, who said in the long term we are all dead, but I do believe that there is a need for long term planning. On the one hand, policy papers can sometimes become impractical, and on the other, policy options are sometimes short of long term vision. Our academia loses its sense of independence, and government begins to devalue inputs from outside its system. There is therefore an obvious interest in strengthening mutual interaction to focus on long term planning. In the language of economics, the cost of investing in long term policy making in time, money, and energy are quantifiable and immediate. Unfortunately, however, the benefits are reaped only in future and all too frequently by successors. These benefits are also hard to quantify since a crisis averted does not register on the popular consciousness. Naturally, the incentive for in depth analysis and long term policy making has always been weak despite the obviously disastrous consequences of ignoring such efforts. Having said that, let me elaborate my perspective of our security environment. There are those who define security solely in the narrow of violent conflict as only. Stop. Starting in 5 seconds. It gives me immense pleasure to be with you on this auspicious occasion of the foundation stone laying ceremony of the new CBI head office in Delhi. This has been a long standing need of CBI, and I am happy that today we are taking a step forward to provide the CBI its own home. I attach great importance to the work entrusted to the CBI. I am happy to say that over the years, CBI, with its efficiency and impartiality, has earned a name for itself. It is a tribute to the good work done by all of you that the executive, the legislature, the judiciary, and the people of our country at large repose high faith and trust in your professionalism, in your capability, and in your effectiveness. I congratulate you for having contributed to the growth of CBI as the premier investigating agency of our country. I greatly value the professional autonomy and integrity of your organization. It is my solemn commitment to our people that our government will never interfere in your professional work, as indeed it has not since we assumed office. From the perspective of investigative and law enforcement agencies, the fast changing national and international political, socio-economic, and technological scenario warrants profound, far reaching, and continuous changes in investigating procedures, practices, and institutional re engineering. New organizational structures, redefining of priorities, adoption of new technologies, mobilization of adequate resources, and enabling legislations are all required to combat the challenges that our country faces due to its organizational structure, vast experience, and an immensely talented pool of trained and committed personnel. The CBI is today uniquely placed to seize the initiative and consolidate its status as the country's apex agency, excelling in investigative methods and technologies, an intelligence storehouse, and a center of research and development. If the CBI has to so consolidate its position, it has to further transform itself, and the initiative for such a transformation has also to come from within the organization. CBI should thus have a forward looking vision of transforming itself into a world class specialized agency. I expect you to set a goal of leadership for yourself in the 21st century. Permit me to share with you my thoughts on some key issues that our law enforcement agencies must focus on in years to come. Terrorism is the biggest national security threat our country faces today. Combating this threat presents unique and unprecedented challenges. The tactics adopted by terrorists in planning, sponsoring, and executing their crimes, often with the assistance of state sponsors, require constant study and analysis. The convergence of terror dealers and conventional criminals presents obvious and acute dangers to our polity. Therefore, our counter-terrorism culture and organization have to shift from a reactive to a proactive mode. We have to develop a nationally driven, fully integrated intelligence and investigative program. This should involve institutional mechanisms for improved information sharing between various central agencies, state governments, and international counter-terrorism partners. We should enhance our capability to be proactive by generating and analyzing intelligence and by creating an environment that is inhospitable for terrorists. We must deny terrorists and their supporters the capacity to plan, organize, and carry out logistical, operational, and sport activities. This requires developing training programs and proficiency standards that enhance investigative capability of counter-terrorism personnel. This cannot be overemphasized. The law enforcement machinery of the country, particularly the CBI, must pursue terrorism investigations and intelligence operations through well trained investigators using the best available tools, including state of the art forensics. new technologies and globalization pose new challenges for crime detection and crime prevention. While these new technologies do enhance our capability to deal with crime, they also offer terrorists, drug traffickers, crime syndicates easier and cheaper access to means to perpetuate their crimes. Technological advances also provide criminals with the potential to stay ahead of law enforcement countermeasures. Our country's vulnerability to cybercrime is escalating as our economy and critical infrastructure become increasingly reliant on interdependent computer networks and the internet. Large scale computer attacks on our critical infrastructure and economy can have potentially devastating results. The ever changing techniques used by terrorists, criminals, and other anti national elements require CBI and other law enforcement investigators and professionals to possess highly specialized technological and computer based skills. Besides ongoing programs aiming at upgradation of skills and technology, external expertise and talents should be actively scouted for and developed. The CBI could take a lead in establishing and implementing new technical capabilities, databases, protocols, policies, procedures, standards, and guidelines, and also support law enforcement operations of other agencies in the country by way of enhancement of their scientific and forensic response capabilities is very much essential for effective implementation of law enforcement in our country. Stop. Starting in 5 seconds. Captain Anthony was working in the year 1985 as a security officer with Bharat Gold Mines Limited, which was engaged in the mining of gold in the Kolar gold mines in Karnataka. On 2nd June 1985, a raid was conducted by the Superintendent of Police at the residence of Captain, from where a sponge gold bowl weighing 4.5 grams and 1276 grams of gold bearing sand were recovered. He was immediately suspended from his service, and the same day an FIR was registered. The next day, petitioner received a charge sheet, and hence departmental proceedings were also initiated against him. The petitioner then moved an application before his disciplinary authorities, praying that the departmental proceedings be stayed till the conclusion of the criminal proceedings, but his request was turned down. Meanwhile, he returned to his home state of Kerala and requested for an adjournment of the disciplinary proceedings. This request was also turned down. The departmental proceedings went ex parte against the petitioner, where he was found guilty of misconduct. On 7th June 1986, petitioner was dismissed from service. During his entire period of suspension, he was not given any subsistence allowance. On 3rd Feb 1987, Captain Anthony was acquitted in the criminal trial on the grounds that the prosecution had failed to establish its case, particularly the police raid on which the entire case was based. The petitioner immediately after his acquittal placed a copy of the judgment of the criminal court before his departmental authorities and prayed for his reinstatement. This was denied, and consequently, the petitioner filed a departmental appeal, which was also dismissed. He then approached the High Court of Karnataka, where his writ petition was already allowed by the court, and his reinstatement was ordered on the ground that on the same set of charges the petitioner has been acquitted by a criminal court, and hence he must be reinstated in service. The state filed a special appeal before the division bench, which was allowed, and the order of the learned single judge was set aside. The petitioner then challenged the order of the division bench of the Karnataka High Court before this court. There were two factors which weighed with the Supreme Court while deciding that case. The first was the admitted fact that the petitioner was not given any subsistence allowance during his period of suspension. The second aspect was that the petitioner was being charged on the same set of facts in the two proceedings, and therefore he had made request to the departmental authorities to stay the departmental proceedings till the conclusion of the criminal case, a request which was denied. This aspect seems to be the most important factor weighing in the mind of this court, as this court was of the opinion that the charges involved a complicated question of fact and law relating to the raid made by the police, and therefore the departmental proceedings should have been stayed, and it should have awaited the result of the criminal proceedings. It was in the raid made by the police that the gold sponge bowl and gold bearing sand were allegedly recovered from his residence. This factum of raid and recovery, which was the fulcrum of the case, stood disproved. Under these circumstances, it was held that the petitioner was liable to be reinstated. Captain Anthony thus must be appreciated for its unique facts, and to our mind, it does not lay down a law of universal application. We say this because, as against Captain Anthony, we have a large number of cases where this court has consistently held that the two proceedings, that is, criminal and departmental, are entirely different, and merely because one has been acquitted in the criminal trial, that itself will not result in the reinstatement in service when one has been found guilty in the departmental proceeding. We may refer to a few of these decisions. In the case of Union of India versus Sitaram Mishra, a constable in Central Reserve Police Force, was charged for being negligent and careless and therefore was removed from service. The facts of the case were that the constable, while removing the magazine of his 9 mm cabin gun, accidentally fired 8 rounds, which results in the death of one constable who was at the relevant time in the same barrack. The constable was held guilty of misconduct in the disciplinary proceedings and was dismissed from service. Meanwhile, the constable was also tried for the offence under section 304 of IPC in a criminal trial where he was acquitted. He thereafter filed a writ petition before the High Court challenging his dismissal from service. The writ petition was dismissed, but later on an appeal before a division bench, the order of the learned single judge was set aside, and it was ordered that since the constable by that time had been acquitted in the criminal court, he is liable to be reinstated in service, and since by that time he had retired from service. Stop. Starting in 5 seconds. The Learned Additional Advocate Journal appearing for the state, on the other hand, the vehemently opposed the present writ application. The Learned Counsel would submit that the family register is not admissible in evidence and the entries made therein are not decisive to determine the age. It is argued that the writ applicant has not placed on record any document of any educational institution. It is also argued that no ossification test was undertaken or no modern recognized method was adopted for the purpose of determination of age. The Learned Counsel appearing for the state invited the attention of this court towards the order passed by a coordinate bench of this court in the case of Ashok versus State of Madhya Pradesh, special leave to appeal. The order passed by the coordinate bench referred to above state thus by a judgment and ordered the additional sessions judge district Bhind, Madhya Pradesh convicted the petitioner inter alia for offence under section 302 of the Indian Penal Code and sentenced him inter alia to life imprisonment in sessions trial. In the cause title of the said judgment and order, the petitioner has been described as Ashok, son of Balram, age 16 years, 9 months and 19 days, resident of District Bhind. The petitioner filed an appeal, being criminal appeal, challenging his conviction and sentence. The said criminal appeal has been dismissed by the High Court, which is impugned in the special leave petition filed by the petitioner. The incident which led to the conviction of the petitioner took place on 26 July 1997. The petitioner claims that the petitioner was born on 5 January 1981. The petitioner was therefore approximately 16 years and 7 months old on the date of the incident. In this code, the petitioner has for the first time contended that he was a juvenile on the date of the incident. His conviction and sentence are therefore liable to be set aside. The claim of juvenility was not raised in the High Court. The learned additional advocate general appearing on behalf of the state argued that the claim of juvenility has been raised for the first time in this special leave petition. The Juvenile Justice Act 1986, which was in force on the date of commission of the offence as also the date of the judgment and order of conviction and sentence. Under the 1986 Act, the age of juvenility was up to the 16th year. Section 7A of the 2000 Act as inserted by Act 33 of 2006 with effect from 22 August 2006 provided as procedure to be followed when claim was juvenility is raised before any court. 1. Whenever a claim of juvenility is raised before any court, this court is of the opinion that an accused person was a juvenile on the date of commission of the offence, the court shall be make an inquiry, take such evidence as may be necessary so as to determine the age of such person and shall record a finding whether the person is a juvenile or a child or not, stating his age as nearly as may be, provided that a claim of juvenility may be raised before any court and it shall be recognized at any stage even after final disposal of the case, and such claim shall be determined in terms of the provisions contained in this act and the rules made there under, even if the juvenile has ceased to be so on and before the date of commencement of this act. 2. If the court finds a person to be a juvenile on the date of commission of the offence under subsection 1, it shall forward the juvenile to the board for passing appropriate orders, and the sentence, if any passed by a court, shall be deemed to have no effect. The claim of juvenility can thus be raised before any court at any stage, even after final disposal of the case, and if the court finds a person to be a juvenile on the date of commission of the offence, it is to forward the juvenile to the board for passing appropriate orders, and the sentence, if any passed by a court, shall be deemed to have no effect, even though the offence in this case may have been committed before the enactment of the Act of 2000. The petitioner is entitled to be the benefit of juvenility under Section 7A of the Act of 2000 if on inquiry it is found that he was less than 18 years of age on the date of the alleged offense. It is true, as pointed out by the learned additional advocate journal appearing on behalf of the state, that the certificate of high school district Bhind, Madhya Pradesh, relied upon by the petitioner is stated to have been issued on 17th July 2021. The said certificate does not mention the date of birth as stated in the certificate. Stop.